When your own ankle monitor tells the cops exactly where you were during a violent robbery, you know things just went from bad to worse. This courtroom couldn't believe how far Christopher Harris had gone, especially after his own mother posted a $50,000 bond to set him free. But what happened next shocked everyone.
Announcement.
Yeah. Oh, that's the other topic. Oh, I
He's
think
in custody. Where's Christopher Harris?
they filed a motion to increase the bond.
Where's Christopher?
He's
In custody?
He's in
He's in custody.
in the other case.
Okay, hold on. So if he's in custody, why did y'all file a motion to increase the bond?
He already posted a bond of 250,000, and then he got out and
How about he's in custody now?
So I just thought,
So why is he in custody now? And is the motion to increase bond necessary? I know, is it necessary?
well, he posted 250 before. I'm just concerned that he's gonna believe it needs to be higher than what it is. Based
What
on-
is it right now?
It's I believe
What
500.
is it? He's 500. Are you Christopher Harris? Okay, who's posting your bonds? Who posted your bond? You had a bond when you were arrested for $250,000. Who did? No, who paid it? You? That's $25,000. I guess did she win the lottery or something? So it's five. So she posted 50,000. Okay. There's a motion to increase the bond. Well, see, here's the deal. You're arrested, so she lost that bond. Whatever she paid, she's out that money, $50,000. Okay, that doesn't bother you at all? That's, I can see you don't seem real upset about it. It would be for me.
The $50,000 bond is still good. He was arrested while he was out on bond for a new aggravated robbery. So this $250,000 bond is
That hasn't been
still
revoked yet. That hasn't been revoked.
correct.
Okay. In 25 CR 1020, Christopher Harris is present with his attorney, Mr. Adams, and the state's attorney. I'm looking at this indictment, which alleges that on or about July 19th of this year, you committed aggravated assault there, and there was a bond set of looks like $250,000 was the bond on July 24th when you were arrested for this indictment. Then afterwards, about a month later in August, a couple of weeks ago, it is alleged you committed aggravated robberies and your bond was set at $500,000. So he's got a $250,000 bond and now a new $500,000 bond. Is that right?
That's correct.
Okay. And was August 25th. Have you seen this probable cause affidavit?
I just got it today. Yes, I just got it today, Judge. With the motion to increase the bond.
Who set the bond on this one? Does it, I guess, a magistrate?
The 500 or the
Yeah.
250?
The new one, the 500,000.
The 500 was set by Judge Jerome.
Okay. So on this first bond, the indictment for aggravated assault, the court has reviewed the probable cause affidavit which states that on July 19th, Beaumont police responded to East X Freeway in reference to a victim of a shooting, and the victim was suffering from multiple gunshot wounds to his lower extremities of his body. And the defendant in this case, Christopher Harris, it's alleged the defendant entered an unlocked apartment, produced a handgun, fired 6 shots at Albritton, causing serious bodily injury, and then fled the scene. So, shot somebody several times and then fled, and so a $250,000 bond is set in that case. So, just a few weeks later, and it looks like we're talking about 5 weeks later, on August 25th, 2025, after the defendant had posted a $250,000 bond, police responded in Beaumont to an aggravated robbery and spoke to the victim, who stated he was robbed at gunpoint by 3 black males who stole his belongings as well as his Lincoln Navigator vehicle. And police located quickly the stolen vehicle at Cardinal Oaks Apartments here in Beaumont, with the lights on and the engine running. And observed someone named Arthur Goolsby standing in the driver doorway with the driver's door open. He was transported to the station, confessed to his involvement in the robbery, and stated that he, along with Harris and Brandon Johnson, the defendant Harris and Brandon Johnson, who were armed with handguns, lured Wilson to pick him up under the premise of going to a party. Once they directed him to a secluded area, Johnson asked Wilson if he could drive the vehicle. Wilson pulled over, at which time Johnson and Harris pulled the guns on Wilson, stole his silver necklace, watch, cash, and told him to run. Johnson shot at Wilson as he was running away. Who does that? I mean, you got him. You know, 3 people at gunpoint and then steal everything, tell them to run and then shoot us. Yeah, it was. Johnson shot at Wilson as he was running away. They all fled in the victim's stolen vehicle. The defendant had an ankle monitor because of his last event, so he wasn't hard to find. And they were able to track his movements and put him in the vehicle at the time of the robbery at the robbery location. Who does that? You know, when you got an ankle monitor and you're going to be tracked, why would you be around some place that causes trouble? And they put him right at the location at the time of the robbery. And so, if that's not enough, an Instagram account belonging to the defendant has a video of the defendant wearing the jewelry of the man's jewelry who was stolen from the robbery. Okay, there is a motion to increase the bond. Anybody else want to be heard? I've read it, the 4 corners.
Nothing from the state, Your Honor. I believe it's.
What's the defense say on this one? Give it your best shot.
Judge, I think at least from what your clerk said, my client has not made a $500,000 bond at all, and the $500,000 bond is the one that you just said was set by the ruling. I believe the state said that he did make a $250,000 bond. So in essence, Judge, that bond has already been doubled to the 500,000, which he has not made. So I'm asking the court to keep both cases at the 500,000 because that's already been doubled, and that's something that he has not made, and it's doubling what he did make. So
All right.
I'll just ask to keep it at that 500,000.
Anything? Statements?
Your Honor, we're just asking for the other one is at 500,000. We just asked for the 900,000 on there because of the nature of the offense after he just committed the very serious aggravated assault, then gets out and does this aggravated robbery, again shooting at an individual. Not much later from when the other, I think within a month.
Did you look into it, bro?
You're not talking to him. You talk to your lawyer. You don't discuss things with him. That's not appropriate. But you can talk to your lawyer, and then he can ask the questions. Unless you want to release your lawyer, you can be your own lawyer. Is that what you want? No. That wouldn't be wise. Anything else? Okay. The court finds as follows. $250,000 bond was set in this first case of aggravated assault, use of a deadly weapon. And not only was $250,000 set, but the defendant was required to have a tracking device. What were the other conditions of bond? Were there any other conditions that it shows? Because I don't have a lot of.
No contact with complaining with witness remain in Jefferson County and to absconds.
Okay. Just a few weeks later, I'm sorry, this was on or about July 19th is the indictment date. And he was arrested on or about July 24th for that first robbery that he was indicted for, then posted his bond for $250,000. 1 month later, approximately 4 weeks later, August 25th, here in Jefferson County, Texas, the defendant commits another similar robbery, aggravated crime using a deadly weapon, where defendant and others robbed the victim, and the court finds that the first court's conditions of bond were pretty serious, and in spite of that, the defendant defied logic that he would be placed at the scene of a crime if he commits a crime because of the monitoring of the income. So it's obvious that the conditions of bond that were set, a high bond amount, and ankle monitoring did not deter him from committing a more violent crime. So he is in custody, and there is no bond. The court finds that there are no reasonable conditions that can protect this community from these bizarre, violent crime need, and for the protection of the people, and to see that the Constitution works, so that we can live in peace. The defendant needs to be sequestered in jail because of his propensity to commit violent crimes with firearms, including robberies, and aggravated assaults. So there is no bond, and his bond is revoked on the $250,000 bond that was paid originally. That is revoked. That is lost to the, so unfortunately to the, his mother who posted that bond, but that's the way the rules are. Ironically, you don't seem, you don't seem too upset, but there are victims in two different situations, but there's also a victim here, your own mother, that you victimized by your actions. You don't seem too upset. I would be. I think that's just normal behavior. But there is no bond, sadly, for your poor actions, and we will set this for trial. Okay? All right. That is all.
The judge didn't just see a repeat offender. He saw a man who turned his freedom into a weapon. And in the end, even his own mother became a victim of his choices. If you thought this courtroom moment was intense, wait till you see the next one we've got coming. Hit that subscribe button and stay tuned, because the next case will leave you speechless.